Welcome to our digital risk discussion brought to you by the fellows of the SIM chapter in Dallas-Fort Worth and the Digital Risk Special Interest Group. I'm Caren Shiozaki. I'm a member of the DFW Fellows, and I'm also a co-founder of the SIG. I'm also CIO of a Santa Fe-based mortgage company, and I'm a senior fellow with the Devine Center of Excellence for Digital Security and Risk. Now, Peter Vogel, my DFW SIM member, fellow SIM member, he's returned to continue the discussion on evaluating cloud service providers. So thank you for joining me again. And again, Peter is an attorney with Foley and Lardner. He's a member of Foley's Privacy, Security, and Information Management and Technology Transactions and Outsourcing Practices. Now, despite the privacy patchwork laws and the recent Schrems decision, which invalidates a significant data transfer mechanism, companies are still continuing to move to the cloud. So because it is a significant component of digital transformation. So I've asked Peter to join us today so that he can talk to us about the evolving privacy law landscape, data protection issues, and jurisdictional issues. So I will turn the mic over to Peter.
Caren, thanks for inviting me to talk today in this podcast about privacy and internet jurisdiction and related things. I think we're all very sensitive to this. And I think that when we read about all the data intrusions that are happening all over the world and data that's being stolen, there are just so many issues at play that there's not one simple answer to how do you look at this. So I'm going to talk today about some of the important privacy issues that are on my plate. So for instance, one of the issues is something referred to as big data. And as early as 2010, the Federal Trade Commission was reviewing big data. And I think we all know from the technology standpoint that the reason we have big data is cheap now. It wasn't 20 or 30, 40 years ago, but it is so cheap now there is too much data. But let me give you an example of what this report is all about. And you can see it's already a 4-year-old report, 5-year-old report, 2016. But what makes this so critical is it's the data aggregators have no legal obligations to clean the data. So what's a data aggregator? I'll give you an example. I've represented Collin County for more than 30 years. Every single day, these data aggregators buy every record of every criminal proceeding in the county. It isn't just Collin County, that's all over the country. They collect all of this data and then they sell it, but they do nothing to validate it. So the Federal Trade Commission is concerned because there are privacy issues associated with that, and people don't know anything about it. And the Federal Trade Commission has warned everybody to be particularly concerned about big data. I don't think there's anything we can do about it. I'm just saying be aware of it. So if your client or your business is in the business of buying big data, you ought to investigate about what the data aggregator can do to clean it and make sure it's accurate. Because if it is inaccurate, you may be causing problems. Now, the critical thing I think that got everyone's attention, and I know Caren kind of teed this one up, in 2018, the GDPR went into effect in the EU. Now, what made this kind of a strange law is it's not really new. It was new because it was different. But let me tell you what it is. Many of y'all will remember this. In 1995, the EU came up with something called the Data Directive. And under the Data Directive, citizens of the EU could go to any computer that had data on them, look at it, change it if it's wrong, or have it deleted, right, to be forgotten. But they didn't enforce it. So what happened was the enforcement finally came around when GDPR. And that is that there's a penalty associated with it, and it's being done by the whole EU rather than a member state. The complicating issue is under the new law, theoretically, because I haven't seen a court case on this yet, that they claim that the data could be anywhere in the world. If it's an EU citizen, then everybody has to comply with GDPR. I'm telling you, I don't know a judge in the United States that's going to enforce that. So there are big challenges on this. And I'll just give you an example. A few years ago, I was negotiating a contract with Toyota for a client. And when I got to the provision that said that Toyota would comply with GDPR, the lawyer had struck that. And I asked her why she struck it. Is that because Toyota doesn't think GDPR applies to the United States? And she said, yeah, Toyota US doesn't think it's applicable, because how can they prove somebody's an EU citizen? So you see, if large international companies don't agree, I don't think it's quite that simple. Another thing is it's worth your while if your business is doing business overseas, or you decide you want to be GDPR compliant. There are a lot of information available on their website. The other thing that goes along with that is look at the fine. Up to 4% of annual global turnover, or 20 million euros, whichever is greater. That's a big number if you think about international operations like Google or Amazon or somebody like that. 4% of their revenue, incredible. Now, what's happened is this has migrated to the United States, as Caren pointed out. And what we're saying is the new law that went into effect in 2020, the California Consumer Privacy Act. And what's important about that is it has to qualify. In other words, every company doesn't necessarily apply unless they fall into the three threshold characteristics. And so even though you're not in California, your business doesn't operate there, doesn't mean you don't have to comply. And then what personal information is covered by the CCPA is also an important issue. And of course, then what are the penalties? Well, the Attorney General can bring an action against you, or a plaintiff can bring an action against you if you're not in compliance. We've seen a number of lawsuits, but they haven't really gotten very far along, so it's kind of still a little early. Now, another important thing dealing with privacy was the 1986 Stored Communications Act, which I'm sure most people watching never paid a whole lot of attention to. And what is it all about, 1986? Not internet data. No, it was about telephone records for Ma Bell. And that is, if you had your own telephone system on your premises, an ECS, then if someone asked for those records, subpoenaed them, you had to provide them. Now, if you were using Ma Bell, or now in today's world, Gmail or Office 365, then you use your remote computing service, and those providers are saying, if the owner of the data doesn't agree to it, we're not releasing it. So it makes it more complicated to get that data. So how does that impact big companies? Well, Microsoft was given a subpoena in New York to produce alleged criminal records, emails from an alleged drug dealer. And they said, we're not going to do that because the data is stored in Ireland, and under Irish law, we can't produce it. So the Court of Appeals overturned their contempt for not producing the data, and it went to the Supreme Court in 2018, and the US Supreme Court heard argument on it. And before they could grant a ruling one way or the other, Congress passed a new law called the Cloud Act, Clarifying Lawful Overseas Use of Data Act, which means the Stored Communications Act applies everywhere in the world. Now, I can't think of another country that's going to enforce it, but that's the way the law is right this minute. So the final topic of discussion today, which is something that's really important that I think we need to keep into account, is internet jurisdiction. And why is that so important? Well, it's important because the law of the country where the data is stored controls how that data can be used. And let me say this about law at 30,000 feet. Many of y'all took business law, so you would appreciate what I'm saying. And that is, laws are what local societies think are acceptable. What's acceptable in Moscow may not be acceptable in Beijing or New York City. It's whatever the local community thinks is right. And so the internet jurisdiction applies in a similar way. The first case that really challenged this was, many of y'all know this jazz hall in New York City called the Blue Note. They went to get the domain name BlueNote.com, and what they found was the Blue Note in Columbia, Missouri was using it already, but this was a common law trademark. So they brought a lawsuit in New York City, and the judge ended up ruling that Blue Note in Columbia was not infringing the trademark, because on their website it said, oh, if you're looking for the New York City website business, here's their address and phone number. So it wasn't an infringement. The second case, well, this one's probably the most important case at all, and that's Zippo Manufacturing, the lighter company, brought a lawsuit. They wanted to get Zippo.com, and the reason that they wanted it was because Zippo.com, the news service, was providing news to over 3,000 citizens in Pennsylvania. So they got jurisdiction in Pennsylvania, but the court ended up with a sliding scale where you have a totally passive website and then you have a very active website. And so you have to go somewhere on that sliding scale to figure out whether jurisdiction applied or not. That's the law everywhere in the United States except the Midwest. In this case, Illinois versus Hemi, there was a decision that they didn't need Zippo. The court kind of ruled, we don't need no Zippo. What they did, they said, look, Hemi is selling tobacco products to citizens of Illinois and not paying tobacco taxes. That's all we need. So I think that's going to be a trend. Now, for those of you who may be wondering, what is that? How does that apply to Zippo? The most important case recently, and it's already 2012, was pervasive software against Lexware. And you could see the court there, the Fifth Circuit that's headquartered in New Orleans, they said you have to look at it on a case-by-case basis. So I think that's really where we are. Now, to me, one of the most fascinating cases of all time was this one, where some anti-Semitic groups brought a lawsuit and got an injunction in France to stop the sale of Nazi memorabilia, because it's illegal in France, on the US website, not on the French website. So what happened? Yahoo went to court, federal court in California, said under the First Amendment, we can sell Nazi memorabilia on our website in the US. And the court agreed with them, and it went to the Court of Appeals, the Ninth Circuit in San Francisco, and they ruled, no, French law does not apply in the United States. So this is a very perplexing issue about how these things get resolved. And so I think it's really important, depending on where your business is operating, to figure out which internet jurisdiction applies to you. So thanks for listening today, and I certainly welcome questions in the future.
Thanks, Peter. I did not know about that Yahoo case. That's pretty fascinating.
Well, let me say this. For 15 years, I taught a course on the law of e-commerce at SMU, Dedman School of Law. And we probably spent more time talking about that one case than any other case every semester, because it is so perplexing. And the reality is the French court, the plaintiffs in that lawsuit, never tried to enforce that injunction in the United States. They only left it in France. Now, let me say this. In France, unlike the United States, if you get an injunction, you can't stop somebody from doing something. You can just get them fined per day. So it's kind of a different model.
Okay. Wow. Always love hearing from you, Peter. I always learn something new. So thank you again for participating in this podcast. I really appreciate it. Now, after you've gone through everything that Peter advised that you learned in podcast 1 and what you've learned in this podcast, and you've gotten an agreement with the provider, your diligence doesn't stop there. In our next installment, we'll talk to you about how to continue to manage contractual risk. So this is Caren Shiozaki. Thanks for joining us. If you have any questions, please email them to digiriskSig@simnet.org. We'll be happy to get the answers, and they will be posted on the DigiRiskSig website. And again, this podcast was produced in collaboration between the Dallas-Fort Worth SIM Fellows Group and the SIM DigiRiskSig. Thank you.